Chief Justice, and may it please the court. My name is Haley Brunner, counsel for the respondent in this case, the United States. We respectfully ask this court to deny the motion for new trial because justice has already been served. Your Honor, opposing counsel has mentioned that Attorney Burns was asleep. However, I would like to point out that nowhere in the record does it indicate that Attorney Burns was asleep. The court should deny defendant's motion for new trial for the following 3 reasons. First, there was no actual prejudice in the defendant's case because the outcome of the new case would remain the same because of the overwhelming evidence against her. Second, there is no evidence of presumed prejudice because the defendant was not denied counsel at any point in the trial. Third, by granting a motion for new trial, the court would violate notions of public policy because courts have narrowly interpreted circumstances that constitute granting a new trial. Moving to my first point, in order to successfully claim a lawyer's assistance was so ineffective as to violate the Sixth Amendment, a defendant must meet 2 requirements. First, the defendant must show that his or her counsel's performance was so deficient that counsel was not functioning as guaranteed by the Sixth Amendment. Second, the defendant must prove the deficient performance prejudiced the defense. In regard to actual prejudice, the Supreme Court has articulated in Strickland v. Washington that there is a heavy burden on the defendant to show a reasonable probability that but for counsel's performance, the results would have been different. There was ample evidence in this case of defendant's guilt, including 1, a recorded conversation between the defendant and an undercover officer posing as a hitman negotiating the murder for hire of her husband. Second, prior evidence of the defendant's murder attempts on her husband. And third, her extramarital lover's admission to the defendant that the defendant intended to kill her husband. Further, the Third Circuit in Ditch v. Grace has held even an attorney's complete absence does not prove actual prejudice if the evidence is so strongly against the defendant that only a few moments of intentiveness do not prejudice the defense. In United States v. Trevelyan, the Third Circuit, the defendant was properly denied relief of his claim that counsel was ineffective for failing to properly cross-examine a witness because nothing in the evidence showed that counsel's errors in his cross-examination of the witness were so serious in light of all the evidence and jury instruction to deprive the defendant of trial whose result was reliable. Regarding presumed prejudice, the Supreme Court in United States v. Chronic identified 3 situations implicating the right to counsel so likely to prejudice the defendant that prejudice is presumed. Number 1 is when the defendant is completely denied the right to counsel. Number 2 is when the defense entirely fails to subject the prosecution's case to meaningful adversarial testing. And third, when defense counsel actively represents conflicting interests. At no point in this trial was the defendant denied counsel, nor was there a failure to subject her case to adversarial testing as evidenced by Attorney Burns' participation in the trial. Your Honor, I see my time has expired. May I briefly conclude?
Yes.
In conclusion, this court should deny the defendant's motion for new trial. As stated, there was no proof of actual prejudice in the trial because the outcome would have remained the same and because of the insurmountable evidence against the defendant. Moreover, there is no proof of presumed prejudice because the defendant was not denied counsel at any point during her trial. By denying the motion for new trial, the court will discourage other criminals from trying to outmaneuver justice, and the relationship between attorneys and the justice system will remain unharmed. Thank you.